ऐसे और वीडियोस के लिए इस चैनल को सब्सक्राइब करें। 3, 2, 1 start. Gentlemen of the jury, you are the sole judges of the questions of fact involved in this case. You are not to be influenced by anything that the court has said or that you imagined that the court has thought in regard to the facts. It is the privilege and duty of the court to call the jury's attention to questions of fact if he so desires. But in the end, you must be your own judges as to what the facts are, under the instructions of the court as to the law. The law you will take from the court and nobody else. The first proposition I want to impress upon your minds, gentlemen, in this case is that you must not be influenced by prejudice or passion or sympathy. That is a vital question, a most vital question for a jury in a case of this character. You have seen this man's leg, you know his injuries, but you must not consider those injuries at all, or the question of damages, if any, until you have considered 2 or 3 vital propositions in the case. It is right for human beings to be influenced by kindness and by sympathy, but it is not right for jurors or courts. Nothing can be more wrongful. You must hold the scales of justice here fairly, impartially, and blindly, and consider the law and the facts, nothing else. You have a right to sympathize and give your own money to this plaintiff if you want to, but you have no right to give anybody else's money except under the law. That is a vital proposition, more vital, I think, in the trial of lawsuits than in any other question. The jury should do its duty, regardless of what is involved and what the injuries are. Courts are influenced by prejudice and passion, and influenced strongly. But it is the duty of the court, as well as the jury, to withstand prejudice, passion, and sympathy. So then, I want you to start out in this case with that understanding that you are to be cool, clear-headed, cold-blooded in passing upon the questions of fact that I shall present to you. The declaration in this case that the plaintiff was in the employ of the defendant, which was a corporation engaged in business, as shown here by the evidence, and that it was the duty of the defendants. There are 2 of them, to use reasonable care and diligence to keep and maintain said steps which have been heretofore described, or stairway, in a reasonably safe condition of repair, so that the said plaintiff might perform all duties and labors required of him safely, and the plaintiffs avers that the said defendants, disregarding their duty in that behalf carelessly, wrongfully, and negligently, allowed said steps or stairway to become and remain in a loose, tottering, decayed, unsafe, and dangerous condition, so that whilst said plaintiff was undertaking, in the exercise of due care, to go upon or over said steps in passing to his said duties, there and then, and there conveying a ladle of molten metal thereupon, said steps did then and there tipperton with the said plaintiff, and as a result of their dangerous and unsafe condition, as aforesaid, by reasons thereof, the said plaintiff was then and there injured and damaged in a certain amount. One vital element of that declaration, contained in every count, I want to call your attention to, where it describes the steps, what the steps were, and what the steps did. The plaintiff does not charge, and you cannot try the question as to whether those originally steps were sufficient or not. They admit that proposition, but they charge that they were loose, that they became and remained in a loose, tottering, decayed, unsafe, and dangerous condition, and that as a result of that condition, they tipped and turned with the said plaintiff and threw him off. Now they must prove that, and the proof of anything else won't help the plaintiff. The plaintiff must prove that they were in a tottering condition, decayed condition, unsafe and dangerous condition, and as a result of that, they tipped and turned the plaintiff over. Now that is their charge, and that they must prove by the preponderance of the evidence. Defendants deny that and every other proposition in the 3 or 4 counts in the declaration. The burden of proof is upon the plaintiff to prove every allegation in the declaration. By the preponderance of the evidence, the greater weight of the evidence. Now it is the duty of the defendants to use due care and caution to furnish a reasonably safe place for its employees to work, and to use due care and caution to furnish reasonably safe appliances for them to work with. In this case, it was the duty of the defendants to use due care and caution and to furnish these steps, which are admitted in the beginning to have been reasonably safe, and to use due care and caution to keep those steps in a reasonably safe condition. That is, to do as reasonably prudent men would do under the same circumstances and conditions in order to keep them safe, the same as you would do if you were in that business, or any man would do if he were in that business. Employers are not insurers. They simply do the best they can. The law requires them to do that as reasonably prudent men. The plaintiff and other employees assume the ordinary risks of their business, the ordinary dangers that they must know and they must see, but it is incumbent upon the plaintiff to use reasonable care and caution to avoid injury. The burden is on the defendant, however, to prove that he did not use such reasonable care and caution.